Welcome to Bird & Bird's Competitive Edge podcast, where we dissect competition law issues to help you understand how they may affect your business. My name is Quinn Liang, a competition trainee in Bird & Bird's London office. In this episode, we'll be discussing the intersection of competition law and horizontal agreements, and we'll be providing a cross-jurisdictional comparison of competition law in Australia, Singapore, the EU, and the UK. Joining us today are three of my colleagues from around the globe. That's Tanisha Kramer, based in London, Jonathan Cow from our Singapore office, and Benjamin Holmes, who's joining us from Sydney, Australia.
Hi, everyone.
Hi everyone.
Hi, thanks, Quinn.
Great to have you all with us. So let's start by understanding the legislative landscape in these regions. So Ben, could you tell us more about Australia's regulatory landscape?
Absolutely. In Australia, horizontal agreements are primarily governed by Part 4 of the Commonwealth Competition and Consumer Act of 2010. This part of the Act addresses restrictive trade practices, which include conduct like anti-competitive agreements, misuse of market power, exclusive dealing, and anti-competitive mergers. These are all assessed on a broad test of whether they have the effect of substantially lessening competition. Parties can apply to the regulator, who are the ACCC, for authorisation or notification where activity creates competition concerns. At a high level, the regulator can grant authorisation where conduct is likely to lead to a net public benefit. That means if the likely public detriment of lessened competition is outweighed by the likely public benefit. In certain circumstances, it can also authorise conduct where it is not likely to substantially lessen competition without the need to consider public benefit. Cartel conduct is an example of conduct that is prohibited on a per se basis in Australia, and it can lead to civil and criminal prosecution. Penalties for corporations have increased and are now at the greatest of 50 million Australian dollars, 3 times the value of the benefit gained, or 30% of the corporation's adjusted turnover during the breach period. Individuals may face up to 10 years in jail or fines of up to $2.5 million per civil contravention. Cartel conduct is an enduring priority for the regulator. For example, a record $57.5 million penalty for attempted price fixing was recently levied against BlueScope Steel, with the company's general manager also being fined $575,000. As another example, in last year's Vina Money case, 4 individuals became the first in history to be sentenced to suspended prison terms for cartel conduct regarding the price fixing of exchange rates.
Thank you, Ben. Now, moving on to Singapore with Jonathan. So, Jonathan, could you shed some light on Singapore's competition laws?
Sure, Quinn. In Singapore, the Competition Act 2004 sets out the general law against anti-competitive practices. It covers anti-competitive agreements, including horizontal agreements, abuse of a dominant position, and mergers and acquisitions that may reduce competition in the market. The Competition and Consumer Commission of Singapore, the CCCS, is the main agency that administers and enforces the Act. The CCCS issued a guidance note on business collaborations to provide clarity on certain forms of horizontal business collaborations, setting out certain factors and considerations in determining whether there are competition concerns from such collaborations. The guidance note emphasizes that collaborations can be pro-competitive, and where there are economic efficiencies, undertakings can consider if the net economic benefit exclusion can apply. Consequences for infringements are mostly financial, 10% of turnover for each year of infringement, up to 3 years, so potentially less severe compared to Australia.
Thanks, Jonathan. Yeah, it's interesting to note these differences. Now, let's delve a bit deeper and take a closer look at the frameworks in Australia and Singapore, both of which are located in the Asia-Pacific region. So, Ben and Jonathan, can you help us understand the similarities and differences in your country's competition laws?
Yeah, absolutely, Quinn. I think one of the more tangible differences is that Singapore's legislation outlines specific exclusions to anti-competitive conduct, along with a lot of guidance for undertakings to make self-assessments. The ACCC's authorisation process, which gives the allowance for consideration of public benefits, encourages early engagement with the regulator. Notwithstanding this, there are specific exclusions in Australia's competition law legislation as well. I also understand that penalties for non-compliance tend to be considerably higher in Australia, as Jonathan mentioned, especially with our rigidity and recent prison sentences around cartel conduct, like in BlueScope and Viva Money. The ACCC also grants full immunity in accordance with its immunity and cooperation policy to certain first movers in responding to cartel conduct, something which I believe exists in the form of leniency programs in jurisdictions like Singapore and the UK.
Yes, so that's quite right. So for cartel conduct, as you've mentioned, Singapore does have a leniency regime. There is immunity for first movers in reporting cartel conduct, and there is also a reward program for whistleblowers. Other cartel members that come forward may get up to 50% reduction in their financial penalties. In terms of engagement, the CCCS doesn't have an authorization process, but undertakings can apply for guidance or a decision from CCCS. The CCCS has also been quite keen on engaging stakeholders to help undertakings better understand and comply with competition laws. There's a strong focus on ensuring competition, but within the context of our economy. So it's essential to understand the unique legal and economic context of each region to grasp these differences.
Thank you both for highlighting those differences. Let's move on to the EU and the UK. So, Tanisha, could you please explain to us how the competition landscapes in the UK and the European Union compare to the Asia Pacific region?
Sure, thanks, Quinn. In Europe, competition law is governed by the Treaty on the Functioning of the European Union, or the TFEU, while the UK follows the UK Competition Act of 1998 and the Enterprise Act of 2002. Both jurisdictions emphasize prohibiting anti competitive agreements, practices, and scrutinizing mergers and acquisitions, but the EU's single market focus has definitely influenced its approach. Notably, both the EU and the UK have block exemptions that exempt certain agreements from prohibitions if they generate efficiency gains. In terms of enforcement, both the CMA in the UK and the European Commission in the EU have the authority to impose substantial fines, which can be up to 10% of total worldwide turnover of each undertaking, so quite significant. Cartel leniency provisions and whistleblowing frameworks are also in place in both the EU and the UK. One difference is that in the UK, dishonest participation in a cartel offence is also a criminal offence, so similar to the Australian regime as mentioned by Ben earlier, which could mean fines and even imprisonment for individuals. Directors can also be disqualified for infringing competition law.
Great. And of course, Brexit has led to some more differences between the EU and the UK's competition laws. What are some of the more notable changes, Tanisha?
Well, after Brexit, the UK now has complete autonomy in the application of its competition law. For example, the UK is finalising its Digital Markets Competition and Consumers Bill, which will give the CMA even greater investigation and enforcement powers. This bill will also amend the Chapter 1 prohibitions so that it applies to agreements, concerted practices, and decisions which are implemented outside the UK but have immediate, substantial, and foreseeable effects within the UK. It's important to remember that businesses with agreements affecting trade between member states will still fall within the scope of the EU competition law as well. Enforcement in these cases will be by the European Commission or the national competition authorities of EU member states. But that said, the UK CMA can still respond to cooperation requests from other national competition authorities.
So that's interesting that the UK CMA is by no means isolated from enforcement by competition authorities in the EU.
That's right, Quinn. Although a binding MOU hasn't been put into place, the competition authorities continue to coordinate parallel investigations and share information with each other. It should also be noted that despite Brexit, pre-Brexit case law in the European courts is still an important influence on UK competition law.
Now, you mentioned block exemptions earlier. Has Brexit also affected block exemptions in the UK?
So, the EU horizontal block exemption regulations were only retained in UK law until December 2022. In January 2023, the UK's new Specialisation Agreement Block Exemption Order, so the SABEO, and the Research and Development Block Exemption Order, so the RNDBEO, came into force. In August, the CMA published its guidance on horizontal agreements, which covers the SABEO and the RNDBEO, as well as, for instance, information exchange, standardization agreements, and standard terms. So while the CMA guidance does have similarities with the EU guidelines, there are subtle differences between the two documents. Interestingly, though, the CMA has also included separate guidance in relation to environmental sustainability agreements.
It's interesting to see these shared principles across regions, but also the gradual divergence that is occurring. As we conclude our discussion today, Tanisha, could you please share some thoughts on what you want our listeners to take away today?
Thanks, Quinn. Across these jurisdictions, the core principle is to maintain fair competition and prevent anti-competitive practices. However, the approach and enforcement differ, reflecting the unique legal, economic, and historical context of these regions. So there are shared principles, but the detailed application of competition law varies.
Thank you very much, Tanisha. Jonathan and Ben, any final thoughts?
I think it's quite clear that each region is committed to maintaining a level playing field for businesses, but with nuances specific to their economy. We can see this in exemptions, exclusions, and penalties, and even the engagement and enforcement by the respective regulators.
Thank you, Jonathan. Ben, any concluding remarks?
Yeah, I'll just say generally, I guess the purpose of competition law is to strike a balance between promoting economic efficiency and preventing anti competitive behaviour. I think we've seen recently that unrestricted markets have a tendency to deviate towards consolidation and consumer detrimental behaviour. And each regime and those who enforce it should probably keep this in mind while adapting to their own economic and legal landscapes.
Thank you, Tanisha, Jonathan, and Ben, for sharing your expertise with us today. That's it for episode 10. This has been Competitive Edge, the podcast by Bird and Bird. We hope you found the information valuable. And if you would like to know more, you can read our article on this topic. You'll find the link in the notes of this podcast. Now, there have been some updates since this article was originally published, but we've mentioned those in this podcast today. If you do have any questions, we would love to hear from you. So you can contact us via email at tanisha.kramer@twobirds.com, jonathan.cow@twobirds.com, and benjamin.holmes@twobirds.com. And finally, if you'd like to stay up to date on competition and EU law developments in Europe and beyond, you can sign up to receive our monthly Competitive Edge newsletter. You'll find a link to the newsletter in the notes of this podcast or on our homepage at www.twobirds.com/competition. Thank you for listening, and we hope you'll join us next time.